Welcome into the Arc Sports Business Podcast. Thank you so much for joining us. And today we're going to look at a college football topic. Now, of course, there's a lot going on in college football. We thought it was just the name, image, and likeness stuff. Now we see that Texas and Oklahoma are potentially going to the SEC, which is a massive deal. And, of course, we've got this 12-team playoff lingering. Most likely that'll be delayed now if Texas and Oklahoma do indeed go to the SEC. But these are both topics that have been talked about a lot. And there, of course, is a lot changing in college football at this point in time. So it's great to discuss these topics. But one thing I wanted to do here to kind of add to the conversation without just kind of spitting off the same stuff that you can find at any news source is to look back at one of the previous landmark decisions, one of the decisions that allowed these schools and these conferences to have the TV dollars that they have, which has created all of this conference realignment, which has created, Nebraska going to the Big Ten because of the better TV deal, which has created Texas saying either we want more money in the Big 12 or we're going to the SEC. Those conferences have the TV dollars. The college football playoff, separate from the NCAA, the college football playoff is effectively owned by the conferences, and they sell those rights to exploit the games to ESPN in this case currently. So we've got this current NIL situation, name, image, and likeness, which went before the Supreme Court. It was struck down 9-0 on antitrust grounds, and Judge Kavanaugh issued not the main opinion, but a additional opinion, which sort of allegedly, if you ask the legal minds out there, he invited future lawsuits to challenge the NCAA on antitrust grounds. And here I'm going to take you back to previous Supreme Court landmark decision where the NCAA was challenged on antitrust grounds, and that was in 1984 when Oklahoma and Georgia brought a case against the NCAA, which went all the way to the Supreme Court. And that unlocked the TV dollars going to the conferences, and it also created a massive increase in the number of games that were available on TV. So let me take you back to pre-1984. So before 1984, the NCAA restricted two things. They restricted the number of games that could go on national television or on television at all, and they restricted the bidding essentially to one network. And it was a network that the NCAA chose, and then there was an allotted, number of games. No team could be on more than 6 times nationally, and the NCAA would sort of allow, say, CBS or the one selected bidder to negotiate with Oklahoma for one of their games, or to negotiate with Bowling Green for one of their games. And then under that NCAA plan, the TV revenue was split evenly. So, among the schools. So basically Oklahoma, for their Oklahoma-Nebraska game, got the same amount as Bowling Green, playing Panera Bread University. No, I'm kidding. But, Bowling Green playing Bellarmine or something. They got the same amount of money as Oklahoma-Nebraska, even though Oklahoma-Nebraska may be a national game and watched by millions, and the Bellarmine Bowling Green is only watched by the parents of the players. They still would get the same amount of money. So I want to go back and talk a little bit about the history. And what I'm going to do here is I'm basically going to read the decision from the Supreme Court. So in researching for this podcast, I was looking through a lot of historical texts about, what things were like before this 1984 decision, why the NCAA had the plan that they had. And really, I think no one does it better than Justice Stevens, who issues this opinion. So I'm going to read the opinion, and it gives some great history. I'm not reading the entire thing, but I'm going to read a pretty significant amount of it that gives the history sort of prior to the NCAA, and then gives some of the reasons why this went down in this antitrust case. So, and I should say that this is an antitrust case in some ways just like this current NIL deal. So I'm going to do that now. I'm going to read through this decision. It's fascinating stuff. I'll also post a link to the full Supreme Court documents if you want to look further. But I think it really sums things up well. So again, this is Justice Stevens issuing the opinion in 1984 Supreme Court ruling, Oklahoma and Georgia versus the NCAA, again being challenged in the Sherman Antitrust Act. Let me say here real quick, just in case some listeners are not familiar, Sherman Antitrust is a consumer protection act. Basically, the sort of litmus test is whether the customer is harmed by business activities. It came about in the sort of turn of the century when there was huge industry consolidation, among Rockefeller and those kinds of things. And it kind of became anti-competitive. It was hard for, railroads to compete. It was hard for suppliers to compete. And they sort of had pricing power, and it caused issues with the consumer getting the best value product. Of course, we saw the consolidation within industries, and then of course JP Morgan, kind of jumping to, potentially buy Carnegie Steel. Then it was okay. Well, now steel and finance are coming together. It was looking like the U.S. was just going to have new rulers, and the rulers were going to come in the form of these companies. And so the Sherman Antitrust came about. Now, of course, what we see now is that it's easy to see, like, if there's only two oil companies in the U.S. and one oil company buys the other, you could potentially have antitrust issues. Or if Pilot buys Flying J and then they go to buy Love's, there could be potentially antitrust issues. Now, one of the problems that's happened in courts is it's harder to tell with software. So you see Facebook buying Instagram. Of course, people just thought they were, nut jobs to buy Instagram for $1 billion. And of course, now it's potentially looks like a missed antitrust, situation. But that's sort of now being challenged going forward. But so that's kind of a basic idea of what Sherman Antitrust is. So, Oklahoma and Georgia and, the most recent Austin case and the name, image, and likeness case is the NCAA, hurting the consumer with what they're doing. So that's how this was challenged. So again, back to 1984, Justice Stevens' opinion on the Oklahoma-Georgia challenge of the NCAA's television plan as it relates to football. So again, this is a decision of Justice Stevens, and I'm going to read it here. The University of Oklahoma and the University of Georgia contend that the National Collegiate Athletic Association has unreasonably restrained trade in televising of college football games. After an extended trial, the district court found that the NCAA had violated one of the Sherman Antitrust Act and granted injunctive relief. The Court of Appeals agreed that the statute had been violated, but modified the remedy in some respects. We granted certiorari. I'm going to need the attorneys to help me on that, and now affirm. Okay, so, and this is where he goes into some of the history. Again, this is Justice Stevens' opinion. The NCAA, since its inception in 1905, the NCAA has played an important role in the regulation of amateur collegiate sports. It has adopted and promulgated playing rules, standards of amateurism, standards for academic eligibility, regulations concerning recruitment of athletes, and rules governing the size of athletic squads and coaching staffs. In some sports, such as baseball, swimming, basketball, wrestling, and track, it has sponsored and conducted national tournaments. It has not done so in the sport of football, however. With the exception of football, the NCAA has not undertaken any regulation of televising of athletic events. The NCAA has approximately 850 voting members. The regular members are classified into separate divisions to reflect differences in size and scope of their athletic programs. Division I includes 276 colleges with major athletic programs. In this group, only 187 play intercollegiate football. Divisions 2 and 3 include approximately 500 colleges with less extensive athletic programs. Division I has been subdivided into Division 1A and 1AAA for football. Again, this is in 1984. Some years ago, 5 major conferences, together with major football playing independent institutions, organized the College Football Association, or the CFA. The original purpose of the CFA was to promote the interests of major college football playing schools within the NCAA structure. The universities of Oklahoma and Georgia, respondents in this court, are members of the CFA. History of the NCAA television plan. In 1938, the University of Pennsylvania televised one of its home games. From 1940 through 1950 season, all of Pennsylvania's home games were televised. That was the beginning of the relationship between television and college football. On January 11th, 1951, a three-person quote-unquote television committee appointed during the preceding year delivered a report to the NCAA's annual convention in Dallas. Based on preliminary surveys, the committee had concluded that, quote, television does have an adverse effect on college football attendance and, unless brought under some control, threatens to seriously harm the nation's overall athletic and physical system. The report emphasized that, quote, the television problem is truly a national one and requires collective action by the colleges. As a result, the NCAA decided to retain the National Opinion Research Center, or NORC, to study the impact of television on live attendance and to declare a moratorium on televising of football games. A television committee was appointed to implement the decision and to develop an NCAA TV plan for 1951. The committee's 1951 plan provided that only one game a week could be telecast in each area, with a total blackout on 3 of the 10 Saturdays during the season. A team could appear on television only twice during a season. The plan also provided that NORC would conduct a systematic study of the effects of the program on attendance. The plan received the virtually unanimous support of the NCAA membership. Only the University of Pennsylvania challenged it. Pennsylvania announced that it would televise all of its home games. The Council of the NCAA thereafter declared Pennsylvania a member in bad standing, and the 4 institutions scheduled to play at Pennsylvania in 1951 refused to do so. Pennsylvania then reconsidered its decision and abided by the NCAA plan. During each of the succeeding 5 seasons, studies were made which tended to indicate that television had an adverse effect on attendance at college football games. During those years, the NCAA continued to exercise complete control over the number of games that could be televised. From 1952 through 1977, the NCAA Television Committee followed essentially the same procedure for developing its television plans. It would first circulate a questionnaire to the membership and then use the responses as a basis for formulating a plan in the ensuing season. The plan was then submitted to a vote by means of mail referendum. Once approved, the plan formed the basis for the NCAA's negotiations with the network. Throughout this period, the plans retained the essential purposes of the original plan. Until 1977, the contracts were all for either 1 or 2-year terms. In 1977, the NCAA adopted, quote, principles of negotiation for the future and discontinued the practice of submitting each plan for membership approval. Then the NCAA also entered into its first 4-year contract, granting exclusive rights to the American Broadcasting Company for the 1978 through 1981 season. ABC had held the exclusive rights to network telecasts of NCAA games since 1965. The current plan, again, this is the plan that's in discussion. This is in 1984. So the current plan, adopted in 1981, for the 1982 through 1985 seasons, is at issue in this case. This plan, like each of its predecessors, recites that it is intended to reduce, insofar as possible, the adverse effects of live television upon the football game's attendance. It provides that, quote, all forms of television of the football games of NCAA member institutions during the plan control periods shall be in accordance with the plan. The plan recites that the television committee has awarded the rights to negotiate and contract for telecasting of college football games of members of the NCAA to 2, quote, carrying networks. In addition to the principal award of rights to the carrying networks, the plan also describes rights for a, quote, supplementary series that has been awarded for the 1982 and 1983 seasons, as well as a procedure for permitting exception telecasts. And separate ingredients with each of the carrying networks, ABC and the Columbia Broadcasting System, CBS, the NCAA granted each the right to telecast the 14 live exposures described in the plan, in accordance with the, quote, ground rules set forth therein. Each of the networks agreed to pay a specified minimum aggregate compensation to the participating NCAA member institutions, i.e. the colleges, during the 4-year period in an amount that totaled $131,750,000. In essence, the agreement authorized each network to negotiate directly with member schools for the right to televise their games. The agreement itself does not describe the method of computing the compensation for each game, but the practice that has developed over the years and that the district court found would be followed under the current agreement involved the setting of a recommended fee by a representative of the NCAA for different types of telecasts, with national telecasts being the most valuable, regional telecasts being less valuable, and Division II or Division III games commanding still a lower price. The aggregate of all these payments presumably equals the total minimum aggregate compensation set forth in the basic plan, except for differences in payment between national and regional telecasts and with respect to Division II and III games. The amount that any team receives does not change with the size of the viewing audience, the number of markets in which the game is telecast, or the particular characteristic of the game or the participating teams. Instead, the quote ground rules provide that the carrying networks make alternate selections of those games they wish to televise and thereby obtain exclusive right to submit a bid at essentially a fixed price to the institutions involved. Okay, so again, I'll kind of jump in here and take a break from Justice Stevens' comments for a second. Basically, what they're saying is there's a minimum aggregate amount set by the NCAA. Then they have these networks negotiate with these member institutions. But the issue is that there's a set number of games and there's a set minimum amount that they have to pay, but they have no competition, so they're going to basically pay the minimum amount. And then it's just the only thing that affects the price is whether it's national, regional, or Division I or II. So basically the idea is that you have this fixed amount of money that's then, divided among the 14 exposures that each television provider gets, and then it's just divided by national, regional, Division II and III, and then that whole mosaic just equals the minimum amount. So there's no change for ratings or schools involved or audience size or anything like that. Okay, back to Justice Stevens' comments. The plan also contains, quote, appearance requirements and appearance limitations, which pertain to each of the 2-year periods that the plan is in effect. The basic requirement imposed on each of the 2 networks is that it must schedule appearances for at least 82 different member institutions during each 2-year period. Under the appearance limitations, no member institution is eligible to appear on television more than a total of 6 times and more than 4 times nationally, with appearances to be divided equally between 2 carrying networks. The number of exposures specified in contracts also sets an absolute maximum on the number of games that can be broadcast. Thus, although the current plan is more elaborate than any of its predecessors, it retains the essential features of each of them. It limits the amount of televised intercollegiate football and the number of games that any one team may televise. No member is permitted to make any sale of television rights except in accordance with the basic plan. Background of this controversy. Again, we're still in Justice Stevens' comments. Beginning in 1979, CFA members began to advocate that colleges with major football programs should have a greater voice in the formulation of football television policy than they had in the NCAA. CFA therefore investigated the possibility of negotiating television agreements on its own, developed an independent plan, and obtained a contract offer from the national broadcasting company, NBC. This contract, which it signed in August of 1981, would have allowed a more liberal number of appearances for each institution and would have increased the overall revenues realized by the CFA members. In response, the NCAA publicly announced that it would take disciplinary action against any CFA member that complied with the CFA-NBC contract. The NCAA made it clear that sanctions would not be limited to the football programs of the CFA members, but would apply to other sports as well. On September 8, 1981, respondents commenced this action in the United States District Court of the Western District of Oklahoma and obtained a preliminary injunction preventing the NCAA from initiating disciplinary proceedings or otherwise interfering with CFA's effort to perform its agreement with the NBC. Notwithstanding the entry of the injunction, most CFA members were unwilling to commit themselves to the new contractual agreement with NBC in the face of these threatened sanctions, and therefore the agreement was never consummated. Decision of the district court. We're almost done here. Decision of the District Court. After a full trial, the District Court held that the controls exercised by the NCAA over the televising of college football games violated the Sherman Act. District Court defined the relative market as, quote, live college football television because it found that alternative programming has a significantly different and lesser audience appeal. The District Court then concluded that the NCAA controls over college football are those of a, quote, classic cartel, with a, quote, almost absolute control over the supply of college football, which is made available to the networks, to television advertisers, and ultimately to the viewing public. Like all other cartels, the NCAA members have sought and achieved a price for their product which is, in most instances, artificially high. The NCAA cartel imposes production limits on its members and maintains mechanisms for punishing cartel members who seek to stray from these production quotas. The cartel has established a uniform price for the products of each of the member producers, with no regard for differing quality of these products or consumer demand for various products. The District Court found that competition in the relevant market had been restrained in 3 ways. 1, the NCAA fixed the price for particular telecasts. 2, its exclusive network contracts were tantamount to a group boycott of all other potential broadcasters, and its threat of sanctions against its own members constituted a threatened boycott of potential competitors. And 3, it placed an artificial limit on the production of televised football games. In the District Court, the NCAA offered 2 principal justifications for its television policies. Again, this is the NCAA's defense here, that they protected the gate attendance of its members and that they tended to preserve a competitive balance among the football programs of various schools. The District Court rejected the first justification because the evidence did not support the claim that college football television adversely affected gate attendance. And with respect to competitive balance argument, the District Court found that the evidence failed to show that the NCAA regulations on matters such as recruitment and the standards for preserving amateurism were not sufficient to maintain an appropriate balance. So we'll end there as far as Justice Stevens' comments, and we'll go back to some summary on the plan itself. So the way I'm going to kind of discuss some of the detail of the case and sort of the merits of what was going on, I'm going to read the decision, and again, I'm going to post the decision and Justice Stevens' comments, post those in the description below so you can get that sort of source material if you're interested. But I think that's the best way to do this. So again, they were challenging on Sherman antitrust against the NCAA plan. So I'll read the decision here. Again, this is from the 1984 Supreme Court decision. Okay, so here's the decision. While the plan constitutes horizontal price fixing and output limitation, restraints that ordinarily would be held, quote, illegal per se, it would be inappropriate to apply a per se rule in this case, where it involves an industry in which horizontal restraints on competition are essential if the product is to be available at all. The NCAA and its members market competition itself, contests between competing institutions. Thus, despite the fact that restraints on the ability of the NCAA members to compete in terms of price and output are involved, a fair evaluation of their competitive character requires consideration under the rule of reason of the NCAA's justifications for the restraints. But an analysis under the rule of reason does not change the ultimate focus of the inquiry, which is whether or not the challenged restraints enhance competition. The NCAA plan on its face constitutes a restraint upon the operation of a free market, and the district court's findings establish that the plan has operated to raise prices and reduce output, both of which are unresponsive to consumer preference. Under the rule of reason, these hallmarks of anti-competitive behavior placed upon the NCAA a heavy burden of establishing an affirmative defense that competitively justifies this apparent deviation from the operations of a free market. The NCAA's argument that its television plan can have no significant anti-competitive effect since it has no market power must be rejected. As a matter of law, the absence of proof of market power does not justify a naked restriction on price or output, and as a factual matter, it is evident from the record that the NCAA does possess market power. C. The record does not support the NCAA's Pro offered justification for its television plan that it constitutes a cooperative, quote, joint venture, which assists in the marketing of broadcast rights and hence is pro-competitive. The district court's contrary findings undermine such justification. Nor, contrary to the NCAA's assertion, does the television plan protect live attendance, since under the plan, games are televised during all hours that college football games are played. Moreover, by seeking to insulate live ticket sales from a full spectrum of competition because of its assumptions that the product itself is insufficiently attractive to draw live attendance when faced with competition from televised games, the NCAA forwards a justification that is inconsistent with the Sherman antitrust basic policy. The rule of reason does not support a defense based on an assumption that competition itself is unreasonable. This is from the National Society of Professional Engineers versus United States. But this is an interesting, I'll jump out here for a second. This is an interesting point here. What they're saying, the NCAA was saying, look, a major component of this plan was that it would protect live game attendance. What the court's saying here is, okay, well, number one, you're playing games at all hours of the day on TV. So if Oklahoma's playing Nebraska on TV and you're worried about how that affects TV attendance for the Texas Baylor game, you wouldn't play them at the same time, and you play them at the same time. And then number two, they're saying, well, okay, but even if it does, you're saying this thing that consumers might want more, which is to sit at home and watch this game on TV, doesn't compete on its own with the live experience, which the court is basically saying, well, that's your problem. That doesn't help the consumer if you think, well, this product is better than the other product, i.e. the TV product is better than the other product, so we're going to limit it because we don't want it to hurt our inferior product, which is the live game. The court's saying, well, that's not an apt justification. And then finally, E, the interest in maintaining a competitive balance among amateur athletic teams that the NCAA asserts as a further justification for its television plan is not related to any neutral standard or any readily identifiable group of competitors. The television plan is not even arguably tailored to serve such an interest. It does not regulate the amount of money that any college may spend on its football program, or the way the college may use their football program revenues, but simply imposes a restriction on one source of revenue that is more important to some colleges than others. There is no evidence that such a restriction produces any greater measure of equality throughout the NCAA than would restriction on alumni donations, tuition rates, or any other revenue-producing activity. Moreover, the district court's well-supported finding that many more games would be televised in a free market than under the NCAA plan is a compelling demonstration that the plan's controls do not serve any legitimate pro-competitive purpose. So again, this is a key feature. What the court's saying here is that you're not creating a more competitive landscape by reducing these TV deals, i.e. you don't put any restrictions on how much money some program can spend on football. You don't put any restriction on what they do with revenues from the football program. You're just simply restricting one source of their income, which has a bigger effect on some schools than others, which would seem actually anti-competitive. So it was shot down in that sense. So again, the sort of two main things that the NCAA was using is justification, the live attendance, and that it was actually creating more of a competitive landscape, were shot down by the court in a 7-2 decision. So again, I just wanted to provide a little basis and history here because there's so much going on in college football. I think this can add to the conversation and kind of formulate a little bit of a basis for a lot of this NIL stuff and a lot of the Texas and Oklahoma now apparently going to the SEC. So we'll see how it all turns out. But again, that's a little bit of history. Thank you for joining us. Please like and subscribe and comment. We would appreciate it. Thank you. Have a great day.